Welcome back, great and wonderful, amazing, auto-piloted, consistency, personified Biafrans and lovers of freedom all over the world. You guys are the best. But remember, do not let your guard down. Our enemy does not sleep. They are not happy. Remember the day of celebration, John the Baptist was beheaded. As we are celebrating the court order, we should know that the people who are dealing with do not obey court order, no rule of law. They don't even know what the law is because none of them read law. They read Islamic law. Do you understand? And they believe that Islamic law is supreme. Until our flag is hoisted above the sky, we will never quit to thrive and to persist on the Biafra restoration. I love you all as you're listening to our wonderful and amazing son, Barrister Ifeanyi for
Human Rights 1948. And also OAU Convention on the Prevention and Combating of Terrorism, which also provide for similar conditions to be adhered to in the extradition of a first citizen. Nigeria was in breach of these fundamental laws. Now, the court held and unanimously that the breach of this law constitutes a bar to further prosecution of Nnamdi Kanu in any court in Nigeria. The court held that the lower court has no jurisdiction whatsoever on the grounds of this. So, in the first place, if you look at the trial, to start the trial, condemn the trial, a court lacks jurisdiction to defend this charge, and as such, Nnamdi Kanu should be released. Now, let me clarify. It is true, granted, that conventionally, when the defendant is discharged of offenses allegedly committed, it's expected that the state may have the right to litigate on same subject matter in exceptional circumstances. But in this case, the court proceeded to hold that in as far as there is an egregious violation of these extant laws, that no law and no court will prosecute Nnamdi Kanu, no court will try Nnamdi Kanu. Even the lower court will not try him. So what's expected in circumstance is for the government to immediately comply with the directives and order of the court. As it stands today, Nnamdi Kanu yesterday becomes illegally held in the custody of the Nigerian government. We were expecting the order to be made available to us by 3 p.m. today, as assured by the Justice of the Court of Appeal. So we can now take the appropriate step to ensure that he's released as quick as possible. It's also good to emphasize that in a similar climate where we have constitutional democracy, where the rule of law reigns supreme, it's expected without being told that the person of Attorney General of the Federation, regardless of that prejudice to this person and office occupied, should have by yesterday honorably tendered his resignation as the Minister of Federation. Because he has exposed this country to ridicule. It's not in doubt that at the point Nnamdi Kanu was abducted in Kenya, because it's also important to emphasize. Just like when I listened to people analyzing this morning, God didn't say arrest. Court of Appeal in this judgment yesterday, in the unanimous didn't mention arrest. They agreed up with us in totality that Nnamdi Kanu was abduction. Abduction, kidnapping was featured prominently in the judgment of the court. They agreed with us because in the manner in which he was abducted in Kenya, he wasn't arrested. Now, and it was partial to the advice of the Attorney General of the Federation that the federal government sneak into another country to abduct a citizen without subjecting him to the extradition proceedings. And on the ground, that ground alone, the federal government, the Attorney General of the Federation should have been resigned honorably without being asked, without a further prompting. I am not contesting the fact they have right of appeal to the Supreme Court. It's a constitutional right. But what is sacrosanct at this point in time is that they must wholly and in totality comply with the order of the Court of Appeal, which directed that Nnamdi Kanu should be released immediately. They will not be in breach of this order, in content of this order, and apply it to Supreme Court for review or for appeal. They must comply without further ado. So it's expected, of course, they were called yesterday to when the judgment was read. Now, of course, unfortunately, I believe that the learned attorney of federation, I don't think he's conversant, or maybe he has the full gist of the judgment, of the fact of the judgment delivered yesterday, because we won't be writing what he said yesterday. So the federal government is being called upon as quick as possible to comply with the order of court. Now, it's interesting to mention to the public, to the world, this argument was extensively canvassed in our various applications, in our application before the lower court, and also on appeal. Now, in 2016, there's a thesis that was captioned United Nations Office on Drug and Crime, country office in Nigeria, published a 691 page of thesis titled Cases and Materials on Extradition in Nigeria. I have the book. Look at the book. This is the book. They call it Cases and Materials on Extradition in Nigeria. Now, it will interest the press and the world to know that in this book, these cases and materials on extradition in law, the forward to this book was written by no person than learned Attorney General of the Federation. He wrote the forward. Now, you understand, me and you understand what forward means. When a forward is written on a book, that means you sanctioned. You have gone through the content of that book and you sanctioned the content. Now, I will tell you something now, because it's important for you to know. Now, in this book, it's at pages 4 to 5 of that book. The Attorney General, that I mentioned to you, having sanctioned that book, critically condemned extraordinary rendition in this book. He critically condemned in page 4-5. I can give you, it's very, very bulky. Condemn extraordinary rendition. In his words, quote, listen to me carefully, in his word, the AG Federation Malami stated, it is easy to confuse extradition with rendition. Rendition is a general term for all procedures, including extradition, for returning wanted persons or aliens generally from a state. Unlawful or irregular forms of returning persons wanted for trial, unlawful or irregular forms of returning persons wanted for trial or punishment include abduction. In his words, include abduction, not what happened in this particular case, abduction and so-called extraordinary rendition. Now, he proceeded. Extraordinary rendition is a government-sponsored arrest. Are you with me? Kidnap and abduction of persons wanted, accused or convicted of a criminal offense, either to the state who sponsored the arrest or kidnap or abduction, or to a willing third-party state. Extraordinary rendition denies a person of the right to challenge his transfer to the requesting or receiving state. It involves the violation of the principle of international laws, especially where the persons transferred are subjected to torture. Are you with me? Or sham criminal charge or trial. The legal affair of 1984 is an example of an attempt at unlawful rendition. After a coup d'etat in 1983, the federal military government of Nigeria requested the British government to surrender Umar Diko, a former minister of federation, alleged to have been involved in corrupt practices. Now, the facts of what happened in Diko's case is very clear to the world. It's a matter of common knowledge. The British government intercepted and refused the phrase and taking him away from the UK. Now, this is the wordings of AG Federation. So you won't tell me that it's not familiar with what extraordinary rendition means and the effect of it on the state. By so doing, this man has exposed the country to ridicule. And I can assure you one thing, because I'm in this case, I can assure you one thing. Some international courts where these matters are pending are waiting for court pronouncement, for Nigerian court to exhaust their legal remedies before they can embark on their own adjudication. They are waiting. And the pronouncement of Court of Appeal yesterday is apt on the point. It will entail further actions before the international court. We also entail certain persons being blacklisted, certain persons being arrested somewhere on account of the gross violation of international laws. it will happen in the course of time. Now, yesterday someone asked about the damages payable, accruable on account of this violation of Nnamdi Kanu's right. Because of course, Court of Appeal yesterday stated clearly that his right was grossly violated on account of the extraordinary rendition, from Kenya to Nigeria. That may interest you to know that we have already filed an action before the Federal High Court, wherein we raised some fundamental issues. We have invited the court to interpret 11 sections of these conventions, charter, and theatres to determine whether the federal government is in breach of this law. And those questions have been answered in the affirmative yesterday, that the federal government is in breach of this law. That matter is pending before Honorable Justice Ekpa of Court Number 5 and is coming up for full hearing on the 14th day of December 2022. And in that case, what we'll be asking for now, the matters having been determined, major issues that are raising before the court to determine upon, to pronounce upon, have been determined by Court of Appeal. We're asking for court to award damages in the sum of 50 billion against the federal government in compensation of as reparation for broad violation of Nnamdi Kanu's right. So it's important to highlight this part. So the court didn't also condemn the executive recklessness yesterday. The court didn't stop at declaring that the lower court has no jurisdiction to attend the charge. The court also, the pronouncement of court yesterday, constitutes a further ban. You understand what I mean by constitution of a further ban? So as it stands today, no Nigerian court will ever try Nnamdi Kanu. No Nigerian court will ever entertain any charge today, as far as this matter is concerned, or any other matter is concerned, without determining the manner in which he was brought into the country. And thankfully, yesterday the Court of Appeal have resolved that issue. That judgment is a watertight judgment. You can agree with me. You were here yesterday. It's a watertight judgment, and I don't know how they are going to escape from it. But what you are calling the federal government to do in the present case is to immediately comply with the judgment of the Court of Appeal. Without further ado, thank you so much.
Thank you for watching. If the video interests you, please share.